Okay, I think we can start. Hello, good morning, everybody. Welcome to this webinar from Maciej Chorosiński and myself. My name is Grzegorz Wozniak.
Hello, my name is Maciej Chorosiński.
Today's webinar will be on one of the hottest topics on the Polish legal market, which is the new law on labor inspection in Poland. But first, let me explain you some technical information about the webinar itself. We intend to go on for approximately 30 minutes to 40 minutes, and then we'll have a Q&A session at the end. We'll try to answer your questions. You can ask questions during the webinar by clicking the question mark button. We will try to answer these questions at the end. You can also ask us direct questions either to Maciek or to me, to our emails, either on our emails or through LinkedIn or on our mobile phones. We'll present our details in a moment. Before we start, let me also explain a little bit about our company. We are the name is Wozniak Legal. The firm has been established in 2007. We are based in Warsaw, about 20 fee earners. We specialize in corporate commercial law. If you could turn back for our details. One more back. Yes, here you have our contact details. So as I said, if you would like to ask us questions after the webinar, because we will try to answer as many questions as possible during the at the end of the webinar. But if you have later some questions, some issues, if you need legal assistance on this topic, as I said, this is one of the hottest topics at the moment in Poland, the reclassification of B2B contracts into employment contracts. Please contact us. You see my detail, Grzegorz Wozniak, and Maciej's detail. You have our email address and LinkedIn profile. A few words about ourselves. Also, I am a legal advisor. I used to work for Allen & Overy, and then I decided to open my own firm, Wozniak Legal. I specialize in corporate and commercial law, M&A, and employment issues is very often part of our due diligence process, our M&A transactions, and now with the recent changes, it will be even more important issue during our M&A transactions. Maciej is our junior associate and also specializes in corporate commercial law. Now, going to our agenda, you will see agenda. I will not repeat it. We will try to give you a general perspective of the changes and of the new situation as regards not only B2B, but B2B and civil law contracts, which mainly are contracts of mandate and contract for specific work. We have these two groups. We have either employment law and employment law contracts or civil law contracts. So starting from a brief overview of the latest changes on the Polish legal market. This new law, which has been very controversial, has been in preparation for many months, has been published this month and will come into force on the 8th of July. What's so special about this law that the labor inspection will get the special powers, extraordinary powers to reclassify civil law contracts, including B2B contracts, into employment contracts, if they decide that the contracts contain some, they call it employment-like features, which is very often subordination, fixed hours, direct oversight, this type of criteria. So there's not so much change in material labor law in Poland, but the change in powers of the labor inspection, which will be much stronger. These are the changes which will come from the 8th July, and actually all companies based in Poland, if they use in their activity civil law contracts, which, as I said, could be B2B or purely civil law contracts, they have 3 months to rethink their strategy, the employment strategy, do the audit, and decide what to do and how to structure their employment relationship. And this is not only changing the law, changing the contract, but also because the labor inspection will not look only at the contract. So if someone tells you that, okay, I can give you a special contract which will be inspection proof, don't believe it, please. There's no silver bullet, there's no magic wand which will turn a defective contract into a perfect contract. The labor inspection will look at the whole situation and will try to interpret whether a contractor is really more under the employment rules relationship, or is it still really independent B2B contractor? This will be very difficult situation for businesses in Poland, and very often the answer will not be easy. But there are 3 months. That's why we started to we will do the whole series of webinars on this topic. We'll try to explain and suggest solutions in this very difficult situation.
When the cooperation will be considered as an employment relationship, according to Article 22, Paragraph 1 of the Labor Code, the cooperation will be deemed an employment relationship if it meets the certain conditions, like the work is performed for the employer under its direction at a designated place and time, and for remuneration. And it is also worth to mention that this article and other key regulations have not changed. So it didn't change at all.
Yes, yeah, this is very important for you to understand that Polish labor law, Polish labor code comes from the 1970s, and actually this definition, because this is definition of the employment agreement, it didn't change since 50 years, and it's still the same. The only change which will now happen, and it's a big change, a very deep change, is this ability for the labor inspection to really make decision whether the contract which they are reviewing is the employment or not.
Now we can move to types of contracts. We have several types of contracts in a Polish legal system. We have employment contract, and this is the most protected. It is governed by labor code, and this type of contract includes full benefits for the employee. We could have also mandate contract. It is based on the civil law. We have less protection, and in the mandate contract we have this is subject to minimum hourly rate. Also, we have a contract for specific work. This is also based on the civil law, but this contract is made for specific deliverables, and there is the lease protection under this contract. And we have also B2B contract, which means business to business. It is for self-employed individuals, and this is treated as a business relationship, not employment.
And it's worth mentioning also that if you look at these types of contracts, we mentioned earlier that nothing changed as regards as definition of the first type, which means employment contract, yes, employment agreement, umowa o pracę in Polish. So definition has been the same for the last 60 years. The same is with other contract, because if you the definition hasn't changed. Monday, contract of Monday, contract for specific work, contract B2B contract. These are all so from the material law point of view, nothing is changing in the Polish labor law landscape. As I said, what changes is the approach, the approach to these definitions, and which probably would be very strict approach and very strict analysis of how they look like. And what is also important is that intention of the parties will not be so decisive in this. So even if the parties say to the labor contractor, no, we want to still keep the B2B contract, what will happen is that if the labor inspection decides that this is really employment agreement, they will issue decision turning this or reclassifying this contract into employment against the parties' will. And these are these key distinctions when we look. I mentioned we have these two words: word of labor law and word of civil law. And labor law, you have subordination, you have social security, you have no risk and no liability, and you have full dependence. So these are these two extreme criteria or extreme points. You have we have subordination, social security, no risk, and dependence. And on the other hand, if we look at the B2B contract, we have no subordination because they are independent, no social security because they pay social security contribution on their themselves, and they have risk and liabilities on their side. So these are main criteria in very general way presented with where the labor inspection and then the court, because there will be appeal to the court. So the final decision, we can say there is a glimmer of hope, because the final decision as to your contract will be really reclassified or not will depend on the judge, but this will be only as a last resort.
Classification, employee or contractor. Generally in Poland, the distinction between employees and contractors, which are sometimes called self-employed, freelancers. This is crucial for tax, benefits, and legal protection, as well as for compliance. And this misclassification can often lead to significant penalties.
Yes, and if we can stop on this slide, I know it may be difficult for you to understand the changes, but imagine this. There's a situation which may happen now. There is no such risk because, as I said, definition hasn't changed. So very often the whole Polish system took into account that the parties prefer the civil law contract than employment, or B2B contract than employment, and actually the authorities followed the intention of the parties, which is important. But imagine now what will happen under the new law. 10 B2B contractors at your Warsaw IT office suddenly reclassified overnight into employment because labor inspector decided that their contracts were not fully B2B. And this may happen like this. And this may happen like this. There's no court is needed, simply one inspection, and the flexible business model crumbles. This is the new law on labor inspection. Under the previous system, under the previous rules, if you were on B2B, but effectively you worked as an employee, you had to go to court, you have to sue the employer and prove your rights in the court, and then the judge could decide whether your contract, as a matter of fact, is employment or B2B. Labor inspection had nothing to do with it. With the new system, labor inspection obtained a special power to issue binding administrative decision reclassifying your contract into employment, even if you don't want it. That's the key difference. And if you look at my example, then 10 B2B contractors got reclassified overnight into employment. This may happen to many companies. That's why I think that the absolute necessity now is to start thinking about this and start preparing for the new law, which, as I said, will come into force on the 8th of July. Just to clarify and to give you the background, so using B2B contracts in Poland is widespread. Many companies, especially in the IT sector, but not only, in many sectors, instead of using a standard employment contract, Polish company often engage people under the B2B contracts. You can register in Poland as a one-man company or self-employed, and then issue invoice for your service to the company. This is very convenient for the company because this company pays just one invoice. This reduces employment costs and administrative burdens for the companies. But there is one hook. It only works if it's really true B2B, not disguised employment. And this will be a problem. If there are many companies which uses to disguise employment, this could end up in a very bad situation for them. And this is binding administrative decision from the labor inspectorate. This is, of course, this is more like a joke or a very simple example how it could look like, because the real complicated situation will be more complicated. In the first step, there will be guidelines issued by the labor inspectorate, so he will try to force the company to change the contracts or to change the relationship with the company. But if the company does not follow his guidelines or his instructions, then they can issue decisions. They can issue a binding decision which actually will change the contract. As I said, even if the contractors will say that he wants to stay on his contract, it will not be decisive. It will not be binding on the labor inspector. So he will look at the situation. He will decide and he will issue decision. We don't know yet how this decision will look like, but the law says that taking this decision, the labor inspector will be able to decide the nature of the contract, working hours, location, so where the work should be performed, and also remuneration. So actually, imagine this: we have a situation where the company agreed something with the contractor, but then the labor inspector will be able to decide all these elements which are typical for the employment agreement himself. So definitely there will be increase in salary, and there will be working hours, which is, the norm in Poland is 40 hours per week. So labor inspector, having looked at the whole situation in the company, will decide how the employment contract should look like, and any hours which are spent after 40 hours per week, because that's the norm, as I said, once again, 40 hours per week. Any hours which are beyond 40 hours entitlement will be treated as overtime. Working on Saturdays and Sundays will be also treated in a special way according to labor law rules. Of course, there will be paid leave, there will be sick pay, social security contributions. So all this happen automatically once the B2B contract is reclassified into employment agreement.
Instead of using a B2B contract, we could also use a contract for specific work. This type of contract offers several advantages for example, programmers and IT specialists, and is often a more attractive and optimal choice than traditional employment contract. However, this contract may be used safely only if the programmer or IT specialist or another person creates an IT work protected by copyright, such as software, codes, or other qualifying creations.
Yes, but also important is that these elements, whether there are any employment-like elements, because if we have these elements of employment, so normally very often these are fixed hours, or direct over supervision on or like typical employee-employee relationship. So this can still, and especially performing work in the company's office. So coming to work every day from 9 to 5, performing the task under supervision of your superior. All these elements can qualify even if you have a contract for specific work, which means you are designing something, you are a designer. It can be qualified as an employment agreement. And we have a short case study based on our experience. Of course, this is going into the future. What will the situation look like after 8th of July? And we focus it towards the IT business, because IT sector will be probably endangered by the whole system, because IT sector in Poland relies very often on B2B contracts or contract for specific work. So and this is short explanation to sum up the situation. The first paragraph is that you can see that the main change in this new law is that labor inspection, that the powers of the labor inspection will change. It will become from a regular control body, which existed and was very important on the legal market. So it will be changed into authority able to directly reclassify B2B contracts as employment relationship. That's a key that's a key change which will happen from July. So the case is this, which I mentioned earlier. Let's imagine the situation where we have suddenly these people reclassified. And by the way, these inspections may also be carried out online, remotely. So there's no need for a typical situation when they come to the office and start reviewing the documents, and it takes forever. It can be done very quickly, electronically, remotely, and they can come up with a decision that these contracts are really are not really B2B. So that's our case study here. Let's imagine that we have an office, and suddenly, because all these people do more or less the same, they are programmers, so suddenly they could overnight they could be reclassified into employment agreements. And what will happen next?
Naturally,
yes,
there is a right to file an appeal, but if you do not appeal, the decisions becomes fully binding and enforceable, and you must then treat the 10 B2B contractors as employees, start paying social insurance contributions and other obligations. And if you do appeal, the decision will be reviewed by the court, but the labor inspector can decide on immediate enforceability of this decision.
So you see that the company will have a choice. They can appeal or not appeal, but it will be very tough choice, because at the end of the day, or at the end of the whole process, it will be reviewed by the judge, and our feeling is that if labor inspector decided that the contract contains some employment-like elements, like subordination, fixed hours, and direct oversight, it will be extremely difficult for the company to prove in the court of law that actually this this relationship is a genuinely B2B relationship relationship B2B contractor is absolutely independent from the company. They will look at all small elements of the whole setup, looking at what email the contractor uses, and very often this is the email in the company's domain. So it will be, even if there is a choice, appeal or not, to file an appeal or not to file an appeal, and theoretically there is a chance to survive or to defend your rights, it will be very hard to decide. So and now we are coming to our conclusions that the only sensible solution to this, if you run a Polish business, and that would be the conclusion for this case study, if you run a Polish business and use B2B contracts and civil law contracts, our advice is this: protect yourself, and you have the 3 months now to really find solutions and to get prepared for the new law. So prepare yourself, defend yourself, prepare yourself, and I would say the 3 main elements. Use proper civil contracts. It is not that civil contracts are forbidden, but they have to be used intelligently, not for every occasion. So use proper civil contracts. Second point, document independence of your contractors, because very often, even if the case goes for trial and the judge will be looking at it, the key element where the judge will be looking at is really whether the contractor was independent in his activity or not. As I said, coming to work every day, working from 9 to 5, direct supervision of his superiors. These are all elements of subordination. So this will it could be decided against the company. And the third element, probably the most important, do the audit of your, not only of your civil law contracts, including B2B contract, but do the audit of the whole situation around do the audit of the whole employment structure in your company, because the labor inspection will look at all small details of this setup. So does the company pay any benefits for contractors? This is not good. If they pay benefits, it could be reviewed as one of the elements indicating that this is the employment relationship. Does the contractor has the email in company's domain? Does the contractor come to work every day? Does the is contractor covered by the general chart of the company when you have division into various groups or teams? So an important thing is that it is not that one item can be decisive. Let's say email address. Yes, we work very often for clients, so we come to see clients, and we are independent from them. So even if we have, if Maciek and me, if we have email address which will be in the company's domain, so one could say very important thing. If you have an email in company's domain, it means that you almost belong to this company. So, but even if we have email in company domain, company is ABC, and we have an email abc.com, there will be so many other elements showing our independence that we can easily say, no, even if we have an email address with the company, this doesn't show that we are employees of this company. So it's important to understand that not one or two elements will decide. It will be a group of features which will then be taken into account by the labor inspector and then by the court to decide whether you are employed or not. And one more, I will repeat once again, the decision or the intention of the parties will not be as much decided. It is not that it will not be taken into account at all, that the parties, contractor and the company say, no, we want to keep this contract as it is. It will not. We don't know how the practice will develop, but the law says that this is not important for the labor inspector to make decision whether he wants to turn this contract into employment or not. So that's our presentation. We managed to finish within 30 minutes, which is great. And now we have 5 more minutes for the Q&A session. And I can see that there are some questions already. So let's start from the, yes, this is a very nice, very good question in reference to what we did. What are the hallmarks of subordination in the Polish employment reality? I mentioned this, but it is important that we repeat. So hallmarks of subordination, and this is true that really it is important in the process of establishing or determining whether the contract is employment-like or independent B2B contract. It will be very important to establish whether there was element of subordination. So hallmarks of subordination, I would say briefly, is fixed hours, direct oversight, so that the boss is looking at this, making evaluation of the work performed by the employee, and 3, integration into the employment structure. So these 3 elements. If you have a company, if you employ contractors, so formally speaking, they are B2B contractors, but they work on fixed hours. There is a direct oversight and there is integration into the company's structure. I'm afraid they are subordinated to the company, and if they are subordinated, if we have a subordination, it means that there is a high risk that the contracts will be considered as employment agreements.
Okay, I can see a second question. How do Polish B2B regulation compare with those of other EU countries? So, in general, Polish B2B rules show some flexibility, but face increasing scrutiny compared to many EU countries. For instance, in France, labor inspection has no right to issue decisions of this type. The reclassification requires a judicial process initiated by the worker, social insurance institution, or the prosecutor's office. For example, in Austria, the system is more formalized and leans toward legal certainty. Authorities or tax offices may audit contractual relationships, but reclassification of a contractor into an employee usually happens through a structured administrative or court process. The key test resolves around personal dependence, for example, fixed working hours, integration into the company, obligation to follow instructions. While audits are common, the final determination is often subject to appeal and judicial oversight, which limits the immediacy of administrative decisions compared to Poland.
Yes, this is correct. Now the third question, the next questions, there are many of questions, but we will just focus on 2 more maybe, and we'll try to answer later directly to our viewers. So what are the best practices to document B2B independence for in the case of labor inspection audits? What are the best practices? This is a very broad topic, and maybe these questions are very. Thank you very much for this question. These questions are very good for us to when we plan the next webinars, the next topics which we want to cover by our presentations. So, what are the best practices? First of all, I would say it really depends on the sector, but generally speaking, it would be that the practice, the factual evidence will have a decisive meaning when it goes to court. So if the company will be able to prove factually prove that the contractor was really independent, and we have to remember that there will be evidence collected by the labor inspector. So there will be battle of two narratives. So if we have, so it is important that I would say it would be very difficult maybe to document independence of the contractor, but it will have to avoid certain things. So like fixed schedules, working hours, attendance list. So if we and it's not only that we have to change, we have to get rid of attendance list or get rid of fixed schedules. We have to create a new situation, a new approach to these to the employment structure, so that these people do not come to work, and contractors they do not come to work every day. They do not sit from 9 to 5. That they are not covered by fixed schedules in the company. So not only that there are no factual evidence about them being involved or integrated in the company, but simply that they do not take part in it. They have to. So that's a big change. Not only, I said at the beginning, there's no silver bullet that I can tell you, okay, yes, we can give you, Maciek and I can give you an agreement which will be like a magic wand. Yes, that this is good agreement and no one can challenge this. No, we'll have to change the ways, change the system, change the method, or change the system how the contractors perform their tasks. So they cannot be dependent. They have to. So in the ideal situation, they should be outside the company. They should not be covered. They should not have not only fixed hours, but even the number of hours. The number of hours. So 40 hours per week is when we talk about hallmarks of employment. So one of the hallmarks of employment is 40 hours per week, and then whatever is above 40 hours is overtime. When we talk about B2B contract, there's no labor code. There's no any specific number of hours. When we have a B2B relationship, when the contractor is providing services to the company, he's supposed to work. He's supposed to provide these services. I keep mixing it, work and services, but he's obliged to provide these services. And what's important is not number of hours, but really the service he's providing. So we cannot talk about any overtime, because he is obliged to provide services without any specification, without any numbers. So when we talk, coming back to these very good questions, what are the best practices to document the B2B independence? Is that get rid of or prepare the new structure, the structure in which there will be no evidence, no easy evidence for the labor inspector to show, yes, if someone is covered by the vacation rooster or is treated like any other employee, he gets benefit from the company because company pays everybody cards to the gym. Yes, so even the small elements can be treated. Oh, okay, yes, he's treated like any other employee in the company, so he is an employee. So it's not only documentation of the independence, but really as a first step, we have to create the situation in the company by changing everything what is around this contractor to make sure that he is really independent, and then during the trial, which if the company appeals to the court and try to prove that he is independent, we will have to show really features of his independence. And then I think if it's a case that any given contractor is fully independent and he is providing services to the company, the case can be one.
Okay, there is one question about the online audit. Can the labor inspector do the online audit? Can I disagree? Under the new regulations, in principle, yes. The labor inspectorate is expected to be able to conduct certain inspections remotely, and it will have broader tools to assess whether a B2B relationship should actually be treated as employment. But this is still very new territory. There are no well-established practical guidelines yet on how exactly these remote audits will be carried out. For example, what documentation will be required, how interviews will be conducted, or how evidence will be evaluated in a purely online settings. While the legal basis is there, the real life applications is still somewhat uncertain.
Yes. So these are, we are running out of time. So I think these four, as I said, later questions maybe we can answer directly. Just to sum up, maybe just very briefly to sum up. So what can be done now if you run a Polish business and you use this civil law contract? So I think there are three main points for you to remember. One, use proper civil contracts. As I said, that the civil contracts are not forbidden but have to be used wisely. Second, document independence of your contractors. And third, the most important one, do the audit of the whole situation before the new law comes into force, which is 8th of July, and then the audit will be basis for amending whatever needs to be amended to avoid the situation where the labor inspector comes to your office and can easily do, as in our case study, that overnight the whole company can be turned into employment, which will be financially very difficult for the company. So that's all from us. We will continue on this subject. As I said, 8th of July is this deadline. So in this period, the companies have 3 months. We will try to cover various aspects of the new law and provide you guidance what to do and how to get prepared for the new law. So please follow our profile. Please follow this film is on YouTube, so please follow our YouTube. We will announce the new dates for the series of webinars devoted to B2B. For this, thank you very much for your attention. See you next time. Thank you.
Thank you.